So we're going to get started now with the final portion. This is generally concerning ethics, but it's also going to be generally concerning anything that concerns you folks. I actually, when Theo was saying cons as concerns, I never made that connection before. Is that what con stands for, concerns? Probably so, huh? Maybe? No, maybe not. I don't know. In any event, I'll lead off with an interesting opinion from the National Academy of Arbitrators that was sent to my attention a few times relative to this matter. And all of these things, by the way, should be in our brochure, are in our brochure for continuing legal education purposes that you can get from the National LIRA website. If you have any questions about how to do that, please ask Bernadette or Emily, because I probably won't be able to help you very much. I'll just tell you to ask Bernadette or Emily. So why don't we talk a little bit, and I'm gonna probably start with Keith to basically tell us what it is, but the question that was posed to the National Academy of Arbitrators, I believe, was, is there ever an exception in light of the COVID pandemic now by which an arbitrator can override the objections of one or both parties, I guess, to an arbitration and say, we are going to do this arbitration using video conferencing? Is that essentially what the question was, Keith?
The question is, it's close. It's a little bit different. It's specifically, can an arbitrator order that a matter proceed by way of a video hearing at the request of one party over the objection of the other party to the arbitration? So it's a little different because if both parties say we don't want to go forward via video, well then that's a really easy answer. That case doesn't go forward via video. It's the party's process.
That's like the same way we're testing the audience. I was testing to see how well you knew the rule. So what did they find? What did they say?
Well, so
who is it, by the way? You're a member of the National Academy. Who issues this kind of thing?
This is from the Committee on Professional Responsibility and Grievances. And this is an advisory opinion to the Code of Professional Responsibility promulgated by the National Academy, the Federal Mediation and Conciliation Service, and the American Arbitration Association.
So before you go on, I'm just a little bit interested. We have a lot of arbitrators on here that might know what that means. But to what extent, do arbitrators have to adhere to certain ethical guidelines, and to what extent is the National Academy of Arbitrators opinions something that need to be followed by all arbitrators or arbitrators who are a member of the Academy?
So arbitrators who are members of the Academy are subject to the code. Those who take cases under the auspices of the American Arbitration Association or the Federal Mediation and Conciliation Service are also bound to follow the code. And so these are, go ahead.
Oh, sorry, go ahead.
No.
Oh, so if you're not, let's say I just happen to be an arbitrator in New Jersey, I'm not a member of the National Academy. They've been sitting on my application for some reason. And certainly the advisory opinion would at least be evidentiary or guiding in some way, wouldn't it?
I would think so. A number of other parties, sometimes in their contracts or other appointing agencies, also indicate the requirement that the arbitrators they use, the arbitrators who are members of the panel or roster, have to abide by the code in the same way. And so it's not limited only to Academy members. So this is an advisory opinion to that code based on the committee's interpretation of the obligations under the code. And so the opinion, and you all have it in the materials if you haven't seen it already, recognizes the voluntary nature of labor arbitration, the principles of mutual consent, and sort of the underpinnings of the labor arbitration process. And it recognizes the obligation of the arbitrator to provide a fair and adequate hearing, which assures that both parties have sufficient opportunity to present their respective evidence and argument. And there's also an obligation that arbitrators have under the code to provide effective service to the parties. So it goes on to note that there may be parties who have agreed either on an ad hoc basis, say on this case we don't want to use video, or on more of a blanket basis, right, in their contracts or in a side letter or otherwise, that we don't want video hearings as part of our process. And again, that's easy in the sense that if you don't, if you have agreement that that's not what's going to happen, then that's not what's going to happen for those parties. The more difficult situation is where there's no such agreement and where one party is interested in moving forward via video and the other is not. And that's the situation that the advisory opinion is dealing with. And it was certainly prompted by the pandemic. I think it has broader application. It's not just under these circumstances, though the circumstances of the pandemic are certainly something that I think the parties and the arbitrator are going to be considering in determining what to do. And so what's really encouraged is for the arbitrator to put on at least their facilitator hat, if not their mediator hat, and talk with the parties about about the case and about the concerns that each party has, and to get a handle on, is there something, where are you coming from on this, each of you, and are there things we can do to address concerns you may have, to address unique aspects of the particular case, and to try and reach agreement on ground rules, sort of like you all have seen over the course of the day. They list a number of the opinion lists a number of considerations, like a global pandemic, for example, the impact on the health and safety of the participants. Is the matter time sensitive? Is there continuing liability? Are there restrictions on travel? Are there family and health considerations of counsel or a witness? Does a party not have the necessary equipment? Is it difficult to prepare and marshal witnesses over video? Are there other limiting considerations like that? Is the nature of the grievance, the nature of the dispute, something that lends itself or really doesn't to proceeding via video? And these are the sorts of considerations that the opinion lays out. And ultimately, the opinion contemplates that an arbitrator may proceed via video over the objection of a party, but that's going to be a case-by-case analysis and an individualized determination. And I'll refrain from paraphrasing. It's there for everybody to read.
I'm a paraphraser, so let's say in 2 sentences, the question is, can an arbitrator order that a matter proceed by way of video hearing at the request of one party over the objection of the other party to the arbitration? And the answer, as far as I can glean, is yes, but you better have a pretty good reason for it, and you better be able to explain yourself for doing
Jonathan,
so.
Do you mind if I weigh in a little bit on this?
No, I would appreciate it if you would.
Sure. So, I mean, from the union's perspective, when you have a grievance and an arbitration provision in a contract, that's a mutually agreed upon and negotiated term and condition of that contract. So, I mean, as far as I'm concerned, I take great issue with this advisory opinion. I think that, and actually the opinion in the second paragraph says, voluntary arbitration rests upon the mutual desire of the parties. So if one party is objecting, I would take great issue with an arbitrator requiring the parties to submit to a video conference arbitration. The whole concept of arbitration, where it has been agreed upon by the parties, and that takes mutual assent, a meeting of the minds. And if the parties don't have a meeting of the minds to proceed by way of video conference, I don't think that this advisory opinion follows the spirit of that agreement. Also, just concerning there being language in a CBA or a CNA, one that is currently in effect most likely is not going to have that kind of language in there. We may start seeing that, but I don't, I can't even tell you how many contracts that I have seen and looked at, and not one has that kind of a provision in there. It's kind of a new concept as far in the world that I work in, but we may start seeing that being a part of the negotiation process.
This is why having a smart panel is both a blessing and a curse, because I can get to point out pithy things and then move on. Because I was just going to say that in the fourth paragraph, first sentence, which I think Brady is alluding to, it says, in the absence of a collective bargaining agreement or ad hoc agreement of the parties prohibiting such an arrangement. So basically what I believe is being stated outright explicitly is that this doesn't apply obviously if you've got a prohibition in the contract. But like Brady said, right now, probably almost no collective bargaining agreements or collective negotiation agreements, which is the parlance of the public sector in New Jersey at least, would they have possibly contemplated, hey, look, let's put something in there that that the arbitration will not be conducted virtually or remotely without the agreement of both parties. James, would you negotiate for that kind of a provision, or would you fight a union at the table if they wanted to put that in, or would you use that as concessionary bargaining and get something better in for your client?
So, I think it depends on the client and the situation and the relationship. But again, my default position is, I'd rather have an in-person labor arbitration at this point in time. So, I don't think Brady and I would have much of a dispute here. Perhaps there's a way, yes, I would consider adding language that would permit it in maybe limited circumstances, or just generally provided that the parties mutually agree to it, including that type of language in there. One thing that I wanted to mention here, you had talked about earlier, like the possible vacature of a arbitration decision based on improper circumstances. I think that this could open the door for that type of motion. And in particular, the advisory opinion, I believe, mentions or suggests that a telephonic hearing is also on the table. And there was a recent National Labor Relations Board decision where a regional director allowed our case, election case hearing to move forward telephonically, which involved examination of a witness. And the board in Washington, D.C. reversed that decision by the regional director, although they were okay with the idea of a remote hearing. The idea that a witness, you have to have the right to confront them face to face, which would include video, was important to them. So, I think arbitrators, particularly if they're open to the concept of insisting upon a telephonic hearing, are risking the opportunity that a motion is going to be made to vacate that decision. And I think there's decent grounds for prevailing in that type of case.
Jonathan, can I make just two quick comments?
Yeah, I was going to go to you, Theo. I wanted to hear if you were outraged. But first, tell us, are you a member of the National Academy of Arbitrators?
I am not.
Okay.
So I did want to point out that, like in other contexts, like for example the commercial context, usually there's a lot of gamesmanship going on, which may or may not happen in the labor context, where delay is usually used by one party or the other to gain an advantage. And so these motions where one party wants to go forward with a virtual but one party does not are actually coming up more and more in the commercial context. And arbitrators don't have the advisory opinion that that Keith alluded to. So they've been relying heavily on the AAA's rules or the provider rules, which basically leave a lot of the discretion as to whether hearings go forward and how they go forward in the hands of the arbitrator. But I'll echo what Keith said. And it's exactly what I love this advisory opinion, because it lays forth factors that should be considered. And it's very important that the arbitrator engage the parties in a robust discussion about these issues and the concerns on either side. Because, and this dovetails to what James just said, these arbitrator final awards are going to be subject to vacator petitions. And under 10A3, a final award could be vacated if an arbitrator refuses to postpone a hearing when sufficient good cause has been shown. And so the issue then is, were sufficient good cause reasons established by the parties before the arbitrator? And if not, then the arbitrator, at least under the commercial rules, would be well within her or his discretion to permit the arbitration to go forward virtually, even over the objection of the other party.
Well, it's interesting you used the words good cause, Theo, and relative to this particular opinion, to get to James' point about, possible vacation motion down the line, the standard that I see, at least in the paragraph that I just read, the fourth paragraph about in the absence of a collective bargaining agreement, it says an arbitrator in exceptional circumstances. So perhaps the burden that would be on the party defending the arbitration award on appeal that they would have to establish is that there were exceptional circumstances justifying the arbitrator's decision to proceed, notwithstanding the strenuous objection of one party. So what would meet the exceptional circumstances? I mean, let's say that there's another outbreak of COVID and we're locked down for another 5 months, God forbid, right? And there's an issue that just needs to be decided. Maybe it's even about work rules and it's about wearing a mask, let's say, and the union's refusing to cooperate with it. It could be a public health safety risk. Maybe that's the type of situation. So Theo loves it. Other people are outraged by it. I guess we're probably not going to resolve it today.
Well, let me circle back to a couple of things. First, that the question that's posed is, can an arbitrator order? Should an arbitrator order is a really different question.
Right.
And I wasn't privy to the discussions that generated the opinion, so I can't shed any light there. But, it strikes me that this opinion is an incentive for parties to cooperate where possible, because it says somewhere down the line at some point, if one party is in favor of this and the other is engaging in gamesmanship, to use Theo's words, that the arbitrator may be able to take some action, may find it appropriate to take some action, determining that a video hearing is necessary in order to provide a fair and effective hearing. And let's not get to that point if we can avoid it.
Right. So obviously you always want labor relations, as James said earlier in the program. You want, the union and management to be able to agree on things as basic as whether to have a virtual arbitration or not. So this is really a worst case scenario, nuclear option, so to speak, whereby an arbitrator has no choice but to make a ruling because the parties have basically given him or her no choice to do so. Let's move on to some other concerns in the arbitration.
One very quick point there is just practically speaking, an arbitrator who's going to pull the trigger there does obviously risk being struck from the list of the parties agreed upon arbitrators. Pretty, that's a good way to get kicked off a list. So just practically a consideration to keep in mind.
It's a good way to not get picked by that attorney again. That's for sure, right? So why don't we look back at the mock arbitration for a minute, and then I'd also like to go into Theo's presentation and talk about some of the ethical things that could come for lawyers.
Jonathan, can I add one thing on there, though? And I recognize the point that James has made, though I think for all of us as arbitrators, we understand that's one of the risks of the profession, and and not with this in particular, this I agree is the rare circumstance, but you decide every case like it's your last. And you make the call that you make based on what you think based on your judgment and based on the contract and based on the party's practice and the record. And if that costs you the next case, that's life in the fast lane. But I do recognize the practical implications there, but I don't think that's how most of us make our decisions.
Right. Well, certainly when you're a big shot Zoom arbitrator taking all the work, you don't have to worry about whether attorneys are going to start striking you from the list. I'm just joking, Keith, but you're doing a great job. So let's talk about the mock arbitration. There was a segment where Lucille, better known as Lou Baker from her theatrical role therein, had a sidebar discussion with James. And, the two of them are on camera, on recording, at least for our purposes, having what was attorney-client legal discussion. What, I guess I'd like to hear from the attorneys, the practicing attorneys first, you're all attorneys. What concerns do you have about the fact that discussion was done on screen, whether or not it's recorded? Why don't you start with you, James, and then go to Brady?
Sure. And no matter how many assurances I get, obviously we did that for purposes of this mock proceeding, but no matter how many assurances I get, I would never have that discussion over this type of platform. What I would do is make sure we moved each of us respectively into a separate room, got on the phone and had a discussion. One, it's just that element of control and trust generally makes you feel more comfortable. In addition, I think that there are legitimate concerns that there could be a potential breach. Obviously, as an attorney, you have an obligation to safeguard your client's confidential information and in your conversations as well. If for whatever reason, someone was recording that meeting, I think there's a chance that, the platform, Zoom in that instance, and Keith would know better than me, but I think that, it's realistic to think that they may, depending on your settings, have now control of that recording in that video. And that in and of itself, arguably, is a breach of the privilege. And if somebody ever subpoenaed, for example, Zoom for a copy of that conversation, they may have to turn that over. So I think that there are, it's a very good question. And I think it's something that attorneys need to take very seriously. And for that reason, it's, something at this point in time, I would never feel comfortable having those types of conversations over this type of platform, despite assurances.
Before Brady responds, why don't you answer that question, Keith, since you're kind of a resident expert about what Zoom does and doesn't do, even though Theo also is too. Let's say that sidebar were not part of the video recording, or were it? I mean, would it be? I mean, you've got a breakout room. You're recording the main hearing, so it probably wouldn't be part of the recording. Is that true?
So it depends. If you're doing a cloud recording where the video file lives, for lack of a better word, on Zoom servers when you're done, that doesn't record the breakout rooms. I usually use a local recording for some of the reasons James just mentioned. I'd rather not have the recording go up there that way, even though I think that the odds of it being an issue are pretty minimal. But when you do a local recording on Zoom, the camera follows the person doing the recording. So if I was doing a local recording and I went into the breakout room, say for a sidebar, and or to check in for a moment, or a sidebar with both attorneys, which is the much more likely way it happens, and I don't remember to turn that off, my recording is going to have our sidebar on it. Now, my meeting settings have this booming voice that'll tell you that this meeting is now being recorded. And so if I actually came into the breakout room with it on, I expect I'm going to be really embarrassed, and I'll quickly turn that off, or one of the attorneys are going to say, "Mr. Arbitrator, what the heck are you doing? Knock it off, turn that recording off before we say anything else," and we'll take care of it that way. But that's, if you're using the local recording, which is a way to avoid some of the issues that James raised, that's one of the new issues that kind of pops up. And I'll add that the suggestion to caucus kind of over the phone and separately is something I've seen an awful lot, and it makes sense for a lot of parties. And it's one of those things, just talk about it at the front end so that everyone understands that's what they're going to need to do, and equip everyone on their teams appropriately for that, rather than having it come up last minute and saying, "Oh, I don't want to use these breakout rooms, but how else can I do this?"
So just to be 100% clear, for those of us who aren't as conversant in the technology, let's say that you were doing a Zoom arbitration just like the one we saw this morning. You were recording it locally. You put James and Lucille, or Lou Baker, in a breakout room, and they had this discussion regarding what questions James was going to ask the grievant. Would that, if you were not in that room, and at that point it's just James and Lou, is it not being recorded by you?
Under those circumstances, my recording will not have their conversation.
But if you were to jump in and see what's taking them so long, or see if they're okay, that it would record that portion of it.
If I were doing a local recording and I left it running when I joined the breakout room, my recording would get at least the start of that conversation until they yelled at me to turn it off.
And as far as you know, if you're doing a local recording, Zoom wouldn't have any kind of omniscient presence whereby it could itself have some ownership rights or recording of James' conversation with Lou.
If it's a local recording, the recording will stay on my hard drive, as I understand it. What Zoom can or can't do in the context of the meeting itself, may be a different issue depending on their privacy policy and everything else. And my understanding is that they have some ability not to listen in so much as to coordinate the different streams, so that, and that's part of how I think they make dial-in via phone work in the context of the hearings or the
So,
meetings.
Not this, yeah.
Sorry, just to chime in, and I want to make sure that I'm clear and that everybody else is clear. And I think this is part of why having an arbitrator who is conversant in whatever platform you're using is so important. And Keith, this is kind of a question for you. Does the arbitrator have the ability to disable other users' ability to make local recordings?
Yes, using the software,
Okay.
but nothing, prevents someone from holding up their phone, right, or just having it off to the side and getting the audio. But I can, as a host, I can prevent others from making local recordings or cloud recordings without my permission.
Okay.
So the only concern from a local recording level of James' conversation with Lou would be theoretically that Zoom may be some kind of a third party involved, and therefore there's someone besides the attorney and client present, and it would be Zoom, although that might be a pretty attenuated argument to pierce the attorney-client privilege, I would think. Yeah.
Go ahead. I was gonna say, I think it's pretty unlikely, but Theo, you may know the technology, the back-end piece of it better than I do.
It's not so much that I know the technology, but it's an issue actually I've been thinking about, because Zoom initially had claimed that it was end-to-end encryption, but then we know that's not true. End-to-end means that it doesn't have any idea what's going on between the communication. But it must know something, because as Keith said earlier, it has to be able to navigate the streams that are being issued. Otherwise, it wouldn't be able to switch between active speakers. It has to know that I'm speaking right now, as opposed to Brady or Jonathan. And so there is some sort of encryption, but I think the notion is that Zoom is not listening to the content, is my understanding. But I think the argument is still open, whether or not, because Zoom is still a passive, somewhat listener on that private conversation, have you somehow broken the attorney-client privilege? I don't know if it's attenuated or not. I just don't think it's been fleshed out.
It seems to me, as someone who doesn't know what they're talking about, that because the client would have no knowledge of Zoom intruding, and it's the client's privilege to waive, that the attorney-client privilege should be strong enough that the client can say that they had an expectation of privacy during that conversation, and that, if there was an incidental overhearing of it by some, corporate monolith like Zoom, that shouldn't pierce or make them, have a partial or a complete waiver of the attorney-client privilege. What do you think, Brady?
Well, again, what I was going to say is that, again, really the way to avoid a lot of this is to, in the ground rules, provide for a different mechanism by not doing those local caucuses. If people are truly concerned, and so many of us are, I cover my camera when I'm not using it. I just don't like the idea of anyone ever being able to access what's going on in my house. I have children, you don't know what somebody could see. So I think that that's really the way to get around it, if people are not comfortable with it. I tend to agree. It's the parties, it's the advocates who, and the clients, with the client's input, who are agreeing to conducting an arbitration by video conferencing. So, I don't know. I think the jury is probably still out on that, but I think it's safer to provide in the ground rules for a different mechanism for engaging in those attorney-client conversations.
Not to send things spinning too far out of the orbit, but what's the difference between that and me sending on Gmail an attorney-client communication to a client? We all know that Google pretty much knows what color socks I'm wearing right now. So, is that somehow a safer venue to exchange attorney-client information than Zoom? And I don't think we should answer that. I think we should probably move on to other things.
Let me
bring
one other thing real quick. There is another layer to, which is similar to what you're referring to, Jonathan, but we all have our internet routers or servers in our house where we connect to the internet. They should be password protected, right? Because they could, if they get hacked into, I don't know who's going to do it, but somebody could theoretically do that. And then again, you have a breach. And You don't want to be standing before a disciplinary board where they're saying, well, did you password protect your internet? And your answer is no. I mean, did you then, breach your duty to competently know how to use the technology, for example? And one practical tip there might be to, on a regular basis, while we're working remotely, to reset our passwords on occasion, including with the internet.
Charlie Cash made an interesting comment that he says that there's software you can buy that's undetected by Zoom that just records everything on your computer. I think there's also less advanced technology in a way that I could probably just take my iPhone, right, and just record what's going on also. So he makes that comment, yeah.
But again, I mean, I think that if there's a concern about surreptitious recording, maybe that gets incorporated into your ground rules from the very beginning, right? I mean, no surreptitious recordings of the proceedings in any way. And then, and maybe you incorporate provisions regarding the way that the parties expect that the attorney-client privilege to be provided for during the proceedings. I mean, those are all things that need to be addressed in that pre-arbitration or pre-hearing conference.
I got another comment from Jeff Bezos from Amazon saying that they like my socks, and the answer is yes, I would like more, Mr. Bezos. Thank you. Please send me some advertisements.
Let me add one. Oh, Theo, go ahead.
Before, when I mentioned that there's screen capturing software that's out there, that's how people used to rip songs off the radio, or off the computer, I should say. When you're streaming music, you can capture that stream just like you can capture this video or audio stream, and so that's why in the mediation context, for example, I always have the parties agree up front that they're not going to record, and not going to record in any other way. Like, in other words, turning on their iPhone or turning on screen capture software. Whether they follow it or not, I mean, that's, you got to hope that people are exercising good faith and are going to abide by the agreements they reach. But Brady's point is correct. You should handle these things right up front as part of the pre-arbitration conference or the pre-mediation conference, so that people know what the ground rules are.
Right, and if you want to act with an abundance of caution, I think counsel has already said that you just you handle things offline in ways that you're more comfortable. Telephone, email, I guess probably telephone, right? Or in person if you're in the same place as James was with Lou. Maybe the two of them could have just walked out in a hallway, maintained a 6-foot distance from each other, put their masks back on, and
could
have
also
a little conversation.
become fluent in Morse code, which could be another.
There you go.
Well, let me note a couple of things. First, one of the joys of labor arbitration is that you're working with parties who are in a collective bargaining relationship. And so they hopefully have some trust. They're certainly going to have to deal with each other tomorrow without me. And the fact that you have that ongoing relationship means that hopefully the repeat players in the process, and I mean that in the best way, the union and the company, or the union and the employer, aren't going to mess around like that, because they know that it's going to poison the well the next day or the next week or the next month if someone finds out about that. And so the other piece on the more technical end, though, is as of Saturday, I think, Zoom has enabled as an option the end-to-end encryption that Theo was talking about. But there's a balance. If you turn it on, nobody can call into the meeting. And so you end up in this with this tension between, do you want to make your hearing more accessible if someone loses their connection or their computer audio isn't good, or it's a witness who everyone's okay taking via telephone, on a one-off exception basis, at the risk of reducing your encryption a little bit, and maybe more than a little bit. I don't mean to minimize or maximize it. So it's something else for parties to think about, where the priorities are and where the right balance is for that particular case and their particular relationship and industry sometimes.
It bears noting there's some interesting commenting going on right now that was initiated by Armando Riccio, who's one of New Jersey's finest management side attorneys, although he only just joined New Jersey LIRA, believe it or not, as a result of this conference, which is regrettable, mentioning the implication of the wiretapping laws. And obviously those do vary from state to state. I think in many states are one-party states, meaning I think that's what New Jersey is, meaning that as long as you're one of the parties on the conversation, you're permitted to record. But what happens if you're recording something where you're not one of the parties? That would be against the law. Other parties are two-party consent state, or everybody has to consent state. So you should probably consult your state laws to see if what you're doing is legal. And then I don't know, Theo, you're a big attorney. Before you were a mediator, you might even know the answer to this. What happens if you're in a multi-state situation where you've got parties in various states, so that it could get even more complicated at that point?
I can't even begin to answer that question.
Yeah. So anyway, I did want to move into a mediation context, if everybody's okay with that. So I was doing a mediation, and the mediator was breaking us out into all of these sidebar conversations. And there were multiple parties to the mediation. So actually my client was being sued, and so was a co-defendant, and they both had separate counsel. So we were all together in this sidebar, and the mediator would sometimes come in, sometimes not come in, but the lawyers are walking around their office, leaving their office sometimes. And I was uncomfortable because, you know, as we all know, under the model rules in New Jersey, or the ABA, it's 433, I think. You're not allowed to talk as an attorney to a represented party. That, you know, I would be in a situation on Zoom where here I am sitting there, the other person's attorney just wandered out of the room ostensibly, unless he's just somewhere off camera. And now, you know, I better switch the subject to, you know, the weather pretty quick, or else I'm talking potentially to a represented party. So what do you think about that, Theo? Ways to prevent, yeah.
I honestly think that's more honored in the breach. I mean, that happens in-person mediations all the time, right? I mean, a counsel leaves to go to the bathroom, leaves the client in the room, and now I don't think I've never had a situation where the attorney is really all that worried, and they just simply don't talk about the case or talk to the person about the matters that are in dispute. So I don't, in the case of a virtual mediation, if you really wanted to avoid that situation, you would simply exit yourself from the private room that you're in, you know, and just take yourself out of the equation until you know that, and peek back in and make sure to see if the other side's attorney has come in, and then you come back.
So basically you just apply the same common sense you would in real life to the virtual setting?
Basically, yeah. I mean, I think there are very salient differences between in-person and virtual, but I try and make the analogy and try and remember that, you know, if we acted a certain way in the in-person context, then think about how that would work out in the virtual context. And I'll just give you a quick example. Like somebody said to me, they were so worried about people listening in on the Zoom mediations, they couldn't maintain confidentiality. I said, how many times have you been to the other side's offices for a mediation? Did you go in there and sweep for bugs before you went into the mediation room? Probably not. So, you know, yes, is it a possibility? Of course it's a possibility if you want to dream up things, but you got to sort of exercise some common sense and decide whether or not it's that important to you. But let me not minimize it. You know, if it is important to you, then you should raise it and you should talk about it and then figure out a way around it that makes sense for you.
What about the Lou Baker James situation? If that were in a mediation where you had set ground rules about confidentiality, would you feel more comfortable about that happening online than in an arbitration, or is it really no difference?
Well, I think yes. I mean, obviously, you know, I would in my welcoming remarks have a very lengthy, there's a little portion that I talk about confidentiality, how important it is in a mediation setting. And in that situation, if for some reason Lou really had to be out of the mediation setting, I wouldn't have sort of left her camera on. I would have excluded her into a waiting room for sure, much like what we talked about earlier during the session with Brady and James. Or I would have asked her to just disconnect, and I would have texted her to call back in when we were ready for her, so that there wouldn't even be that. I would just avoid the whole situation by presenting those possibilities.
Well, because mediation, you know, is a lot different than an arbitration, which arbitration is a lot of action, right? Whereas mediation, you know, depending on the number of parties, the mediator is jumping around, and, you know, the parties are kind of sitting there waiting for the mediator to come back in the room, waiting for the next volley, what they're going to throw out the other side. That's all attorney-client privilege. So if I'm following the James Lou arbitration rule, where we're going to, you know, talk on the telephone, then basically, you know, we're going to be signed off or, you know, muted 90% of the time that we're on the Zoom call, because we're on the telephone the whole time. Right?
Yeah. No, I think that's right. And that's why I indicated earlier, and I do a lot of telephone mediations, and you could do the exact same thing on Zoom, right? If you anticipate being with one side for quite some period of time, let's say 45 minutes or an hour, and you know that in advance, you can tell the other parties, look, feel free to disconnect. I'll let you know when you can come back in, because there's no reason for you to hang out in the platform if you know I'm going to be way late for an hour or so. And this sort of disconnect, reconnect, it sounds cumbersome, but in fact, it's actually not that big a deal. I do this all the time in telephone mediations and it works out perfectly fine. You just have to set expectations and just manage the parties' expectations about when you're going to be coming back. And sometimes what I'll do is I'll check in. I'll just say, I'll text you 20, 30 minutes in and let you know that whether I'm still with them or not and whether I'll need you sooner, right? Otherwise, why don't you plan on dialing back in at 3 o'clock and we'll be ready to go at 3.
Are there any other ethical, specifically ethical issues that any of the presenters want to talk about? I know I kind of skipped you, Brady. I wanted to hear from you specifically, but anything else on that before we kind of open it up to more general Q&A?
I don't think so. I mean, I think, you know, as an advocate, you want to make sure that you're doing everything that you can to represent your client, and giving them the opportunity to present their side of the story. And I think what it comes down to is we need to make sure that this platform is appropriate. And I think that goes to the very function of who we are as advocates, and whether or not we can deliver that via this platform. And that, you know, I think that requires ethical considerations, and it requires an in-depth look at both the arbitrator, the facts of the case, the law surrounding the case, the parties, you know, labor relations, because it's not always harmonious. And, you know, the relationship between counsel. You know, there was a question asked regarding if counsel's talking over each other. And James and I, again, we talked about this before. You know, we were trying to talk over each other a little bit so that you could see, is that recorded? Is that going to be accurately transcribed? Those are all issues. You know, is the record clear? Those are all issues that I think we need to consider when we're determining whether or not to go forward. I think these all play in to each other.
I'll tell you some concerns that I have about the virtual setting for both mediation and arbitration, and I'd kind of like to hear from everybody on this. And also, if the audience could start typing in questions if they have them, that there will be a difference in mediation because people have an incentive to leave. So if you're having a mediation in person, and I have to get my client to get in their car and drive to Princeton Junction to Theo's office, I feel, and as the attorney, I'm always preaching mediation, right? I say, come on, guys, let's stay a little longer. We've been here for 5 hours. So to what extent is that aspect of real life mediation lost? Because, you know, I'm in my house, I'm at my office, I could just sign off. You know, I get my 2 free hours under the court rule, fine, peace, I'll see you later, and sayonara, right? And I don't have that in-person stake. I've been here. You know, I've been sitting in this office. Let's get a deal done before the end of the night and just get it hashed out. I saw, Theo, you nodded your head. Is that something that you think is
That's
real?
definitely a drawback. It's very easy to leave a mediation. Simply, it's so easy, right? You can simply just disconnect, turn off the computer, and you're done. You don't have to get in the car and drive an hour back home or something like that. It's one of the drawbacks of doing a virtual mediation. You know, that's sort of the flip side of saving all the money and time and expense. But you know, I think that's partly why it's important for the mediator to be cognizant of the party's engagement in the process, to not leave them hanging out there in that breakout room for too long. I mean, my practice usually is to try and make sure I check in with them every 20, 30 minutes, some way, so that they're not left alone to their own devices. And that gets even worse as the hour goes on, right? As you know, in a typical mediation in person, you know, the so-called witching hour that mediators always point to is the 4 o'clock, 5 o'clock time period where magic happens. You know, in that situation, by then, if they've been on Zoom for like 6, 7 hours, this may be a real problem to try and keep them there. And I think you have to think of ways to engage them to make sure that they don't simply say, you know, I'm done. I'm just going to go have dinner with family now. Forget it. I'm done for today. And that's why you don't be inhibited in stopping the session early to reconvene.
It's almost the opposite, right? Yeah, Brady.
Well, I was just going to say, I think that has to do also with, and it really speaks to knowing your client, and knowing what kind of person or organization the client is, because a video conference mediation may work very well with a certain kind of client, but there may be some individuals that just really need that face-to-face. I don't know if it's pressure that the mediator can put on, but there is a certain degree of that, showing what the different sides are, and the pluses and minuses and weaknesses, and benefits of settling the matter. So, I really think that, everybody can tell Theo's really skilled at mediation, and he does a lot of these by teleconference or by video conference. And he can probably tell by the parties, in assessing the parties, whether things are going to work out. Maybe he can't, but I think as an advocate in going into a mediation, I think it's really important to know your client. And that's not going to be 100% foolproof, but I think that, you need to be sensitive to those issues in going into a mediation.
Let's talk about arbitration for a second. What I've seen so far, just in my partner's experience now on the 9th day of this arbitration, is that there may be a tendency, maybe I'm wrong, that people feel like they can spend more time than they would in person, asking questions, preparing, taking breaks, calling witnesses, because it's easier to get witnesses, right? You don't need to necessarily ferret them out of wherever they are, clear their schedule the same way. And maybe you just feel a little bit more relaxed in the Zoom setting because you're in a comfortable environment, and you just talk a little bit more, you ask questions a little bit more, you take breaks a little bit more, and the thing just drags on a little bit more. Does anybody agree or disagree with that? Keith, you look like you disagree.
I don't know that I've seen it happen that way. I think the Zoom hearing days take longer because there's more that you have to manage, and just flipping through a new exhibit is a little bit more of a production. You've got to email it, you've got to wait for the other folks to get it, give them time to look at it, say, well, what's this on this page? Or what page are you talking about, right? Unless you've really gone through and made sure everything's got a clearly identifiable page number. I think you get some Zoom fatigue, right? Like the way Theo talked about, it's a lot of time to be kind of staring and looking into the screen. I think it's really stressful, especially for someone who's doing this for the first couple of times. And so I think you take some additional breaks because of that. I was working with a lawyer who, I have a lot of respect for and has been doing this a long time. And they had a lot of trouble just getting things running, and it affected kind of the tenor of the day. And so I tried to make sure that they had additional breaks, in an appropriate way. So do you want to take 10? And the other side was fine too. They'd been through the same thing a few weeks back. But it's a lot to manage, litigating a case and managing the technology at the same time. And that, I think, is something that we all need to acknowledge and kind of make allowance for. So I haven't seen as much of I'm going to keep doing this because I'm easy, because it's easy to get, to keep asking questions or get a hold of the witness. I haven't seen that prolong the day. It's more the sort of the adjustment.
And I have to say, speaking personally, I'm a working mother. I have kids who are doing remote schooling, and doing a Zoom arbitration from my home, that's a whole extra added layer of stress, because you can see the door behind me. I don't know who's going to walk through that door at any moment. So, people are being pulled in a lot of different directions. And so those are all considerations that I think people need to take into account, especially where there is Zoom fatigue or platform fatigue, and things might go a little bit longer. As things relax a little bit more and open up, people may be able to go into their offices, specifically if schools are closed. I don't know that we all know how this is going to play out. So I think that as a working parent, I know many attorneys are working parents. So that's an extra layer of stress that does get added onto this whole process.
Alira, we're always interested in the future of where things are headed. So I'm going to ask James a question, because I know, James, you worked previously at Jackson Lewis, which we all know is a national labor firm. that kind of became national, I think the same way as Littler Mendelsohn and many of the others, by just kind of buying up these colony offices in various states, as opposed to Gibbons, which is, a regional powerhouse. But, I worked at Abraziz and McDermott in New Jersey, which was, probably in the 80s before all the national buy mergers were going on. They could have represented any Fortune 50 company in New Jersey and no one would bat an eye. That's less likely to happen now. So what about the idea, so Jackson, Lewis, Littler, Mendelsohn, we need to have our attorneys in New Jersey. We need to have our attorneys in Minnesota. We need to have our attorneys in Atlanta. Well, what about now that, like, in the workplace, people are saying, well, maybe you don't need to go to work because you could do it remotely. Why wouldn't I say, you know what, I really love my attorney. I'm Coca-Cola, my in-house counsel. He's the best at arbitration. He's better than the others. Or I love my attorney who's in the San Francisco Littler Mendelsohn office. Or I love my attorney at Gibbons, and we're opening nationwide. So why don't I just have James, and he could do arbitrations throughout the entire country. He could do it on Zoom. I don't have to pay for him to fly, and it'll be great.
Yeah, that was kind of a loaded question there, and I don't know if I'm fully equipped to answer it, nor have any authority on which to answer the specifics in which it was raised. But one, I think, benefit you're pointing to in the field of labor relations, whether it's a labor arbitration or proceeding before the National Labor Relations Board, is that you could be admitted in one state and practice on a national level. And yeah, that's something that's advantageous and perhaps something that clients may look to do with their preferred counsel across the country if this remote setting continues. So I'm not trying to dodge the question. I just want to answer it intelligibly and in light of the fact that I don't work for any of those firms.
Well, you work for Gibbons, but you wouldn't turn down the work if a client wanted you to do a Zoom arbitration for all their Zoom arbitrations for them, where the other side would agree. And I won't make you answer that question. I'm just trying to point out the fact that maybe that's something that we could see going forward. There are a lot of things to be resolved. It may just be that everyone will agree with what seems to be the tenor on here, that Zoom is just pretty much a Band-Aid on the situation, or Zoom or WebEx or whatever else you want to call it. We're using Zoom, like Xerox kind of is just a broad generic term, that we're doing this because we're in a lockdown type situation. And when things return to normal, there won't be any need for this except under rare circumstances. But who knows, maybe that won't be the case. So I thank all of the presenters. I think you all did a terrific job. I hope that everyone who came enjoyed the program, learned something, and we'll be in touch with you about CLEs. To get the program that I've been referring to, Emily or Bernadette, maybe you could describe the process to go on the website to do that, to get the materials.
To get all the
opinion,
handouts?
yeah, right, everything that's in the booklet we put together.
Sure. I sent everyone an email last night. There's a link to it in what we call our C3. It's a discussion board. It's a community for everyone who attended today's training. It has all the handouts, like a 60-some page PDF, and it also allows you to look up any of the people that you met here today or heard speak here today.
You went out, Emily. You want to finish it, Bernadette? I think you know what she's going to say.
I
right?
think what she was going to say was that it'll allow you to connect and continue the conversation with anyone that you met today, or questions. If you guys have questions, you can throw them out and continue the conversation on that C3. One thing though, if you didn't notice in the email, there is a little bit of a lag connection because it is an
And send them a private email, or you can always train.
You're back. You froze for a minute. We lost you.
So everybody should be able to go on the
All right,
website and download the booklet that includes this opinion and some other materials that we have.
Right. If you don't have access, give it a day, and you should have access if you were a late registry.
Great. And I just want to say, as a shameless plug, New Jersey Lira, thank you to all of our new members. We hope that you'll come to our programming, whether it's virtually or in person. However, that ends up being in the fall. I think the state's reopening, so we hopefully will be back to in person, maybe with more social distancing than we're used to. And, you know, I know LIRA is having its annual conference on June 13th through the 16th. So that's something that now that you're members, you probably might want to take advantage of. There's all kinds of seminars you could pop in for 1 or 2 after you've registered, right? You don't have to register. You don't have to go. You don't have to spend the entire weekend. You could spend some of the weekend and see some great programming. So thank you for everybody. You know, please follow up with us with any questions that you may have, and have a great rest of your day.
Thank you, Jonathan.
Thank you, Jonathan.
Take care.
Thank you, Jonathan.
Thanks, everybody.
Thanks, everybody.
Thanks, everyone.
Theo.
Thank you, everyone.
Brady.
Thanks. Enjoyed it.
Great, Jonathan.
Thank you. See you later.
All right.